We cannot turn the clock back.
Yes.
Adjourning the matter, it will cause prejudice to you. Can we take it up on 4th? No.
She is being informed that her senior is due to some health problem. That's why they are
Anyway, no public interest. MS N. Hondik, learned counsel for the appellant, submits that her senior, who is your senior?
Titaba.
Mr. Titaba, who is leading in this matter, is having some health problem. Please stop. Therefore, she prays that this writ appeal may be adjourned to adjourned for 4 weeks. Please stop. Mr. T. Garam, learned counsel for the respondent number 8 is present and raises no objection. Accordingly, let this matter be listed after 4 weeks.
Much obliged.
Yes, sir.
May I please, my lords? My lords, as I was submitting, local self-governance is the,
It's okay. Please come to page 57.
my lords. Yes, my lords.
Page,
Para 40?
page 56. Page 56.
Yes, my lords.
Para 39.
My lords. FIR has been registered.
It has been
Long-
registered.
Not, that's only a localized issue, your lordship would have.
It's registered. Was registered by SSC. When it was registered?
It was registered on 5th or 15th of
Yes.
March 2024.
Investigation is going on.
Must not in the entire issue. There are various other issues. If your lordship would have my prayers, if your lordship
Yes.
would have for 1 minute, at page 103. That's only one part. The corruption part is only one part of it. There is another aspect, and that is the Panchayati Raj governance system, which was introduced by a constitutional amendment, has laid down that a state finance commission has to be formed, and without that, no funds will be released. And that's my first prayer, if your lordship would have, is investigation by the CBI, because I have been making my complaints along with many other conscious citizens of the state of Arunachal Pradesh for a very, very long time. I'm sorry.
You are on 14 and 15 Finance Commission recommendation.
Alex.
What is the amount?
No, its amount runs into hundreds, if not thousands of crores, which have come. And that is one of my main prayer and grievance is also
You must
that
be knowing how much the grants have been total grants have been released by the central government.
there are
They're
two
14
aspects.
and 15.
In 14 and 15.
14 and 15, yes.
Para
Yes.
34, if your lordship would have. It's
Just
reflected in
saying-
para 30.
Sir, just saying siphon of the money, grants money would not suffice,
Sorry, madam.
would not be suffice. Just saying that the grants of the by the 14 and 15 Finance Commission recommendation has been siphoned off. That will not be suffice. You have to give some
I'm not
data.
saying that. I have attached loads and loads of documents, if your lordship would say, which I have.
It's not the volume of the pages or the
No, no, I am
documents.
specifically stating
The
that's why I was,
substance has to be there.
therefore I was inviting my lord's attention to paragraph
Yes.
34. If your lordship would just come to my prayers, if
Yes,
just
yes.
for 1 minute, then I'll take.
Page
an answer.
103,
Yes,
103,
105, if your lordship.
105.
I will satisfy all my lord's queries, but if your lordship permits me to just put forth my case.
Who are you?
I am a conscious citizen of Arunachal Pradesh and also a practicing lawyer who has done, along with some of my colleagues, detailed research, including going to the places, getting photographs, and collecting of all the material for your lordship's consideration, which I have also given to various investigating agencies, and they are not doing anything. The
Is-
first FIR,
As a lawyer, do you have time to do all these things? As a
My lord-
lawyer,
can I just say this? A duty cast upon an officer of the
it's
court
okay, we understand, but then,
travels, and I am just quoting Chief Justice Ramana's.
off the record, I'm saying. As a lawyer, do you have, get a time to do all these things?
Well, I am bound by,
Where the construction works is going on, how the state is functioning.
because I am,
You're
I am
a
not-
citizen, you must, but then do you
I-
get the time?
I will not use my words, Milords. I would use Chief Justice Ramanna's words to explain that, which Justice Ramanna has clearly said that lawyers' duty is not just inside the court. They have to work for establishment of justice system
Equally, lawyers,
outside the court.
equally lawyers' duty should not be to impede public works.
Absolutely not. The effort is,
Put hindrance on the public works
if that is my intention, which can be reflected
Unless-
from any of my acts,
unless
I
there
will
is
be
a
out of the court.
substance.
I'm showing substance, and these are things, Milords, which are. Can I take my lords to my prayer number 6, if for a moment? Now, this is the route. Prayer 6 at page
Fulfill its
105.
constitutional mandate and constitution, what is this?
That a functional state finance commission is established. There is no financial commission in the state of Arunachal. Despite reminders and despite, if your lordship would just permit me to read one annexure, central government has clearly stated in their guidelines that we
You
will
are
not.
challenging the provision of Panchayati Raj Act also
Yes,
in a PI,
yes.
in a PI.
Sorry, Milords. Yes, in a PILM.
How-
Because that's in direct contravention of the constitutional provisions. Because they have violated that and they have tried to justify, overrule the constitution by keeping a provision in the act drafted by and passed by the state legislative assembly, which is in direct contradiction to the
And
constitution.
all this work on your own soil has been done in the year 2018.
No, starting from that. And 2018 is very important because there were no elections for 2 years of the Panchayati Raj, of the Panchayat. And all these in a very hurried manner.
If my memory supports, all those things were it was a litigations were there for non-conduct of election in time for the Panchayat.
Hello.
There was a litigation.
Yes. But there are constitutional provisions which will override any administrative or legislative decision.
There was a litigation. Have you tried to find out?
I have not found out, but my point is absolutely different.
There was
from
a
that.
judicial order
Even if,
to conduct
yes,
within certain period
yes, but that,
before this court.
yes, Manoj, sir, I'm not aware of that. I confess that.
That is
but-
why precisely why we want that you should come up with all the clear facts and
that
the relevant facts.
what I am submitting before my
If you
lord
are-
consideration is,
If you don't have, if you are ignorance of those judicial orders,
that
which was a,
I am on a totally different point.
yes,
Let's I bow down, even if there was an order, judicial order for not holding elections. Even then, my point is not holding elections or not holding elections.
Then-
My
then-
point is,
then-
my lords, how could you spend money without getting it passed from the panchayats? That's my
Well,
point.
so us,
So you have,
so us,
yes, that's what I was.
yes,
So if your lordship first
Yes.
permits me to take my lords to the prayers.
yes.
Prayer 6, at page 105.
Yeah,
Why direction and order should not be passed against state government to fulfill its constitutional mandate and constitute a functional finance commission in the state, which is not there. No judicial order.
just
to
read it
prevent that.
again. Constitutional
seven-
mandate and constitution, function, what does it mean?
Let's, in 1993,
Just read.
Constitution of has been missed. Constitution of a functional
We're
state.
not able to understand the
Correct.
language and meaning of this.
Can I take my lords to the amendment of the constitution, which was specially made for this purpose only? 73. Article 243. 1.
It's okay. We'll just, today, the best we can issue, we may
Let's-
issue notice, that's all.
Let's-
Yes, what do you say? I think, this 14 and 15 Finance Commission. There was a challenge, I think. Do you have you any idea?
Loss, I'm not getting lost.
This, present same issue
Loss.
regarding the misappropriation and all those allegations. There was a litigation in this court
Loss. Yes.
with
only
regard to 14 and 15.
14
Finance
and
Commission.
15. I think that was
And-
pertaining to Panchayat, but in regards to the police department, one was there loss. In
Not
police,
forest department grant, 14 and finance, 14 and 15 Finance Commission grants.
anyway, I'll find out.
If that is so, I think one of us, we may not take up this matter. Can we take it up tomorrow? Because reason is very simple.
Let's, I have to travel back if you're not.
No, problem is, one of us was a part of that litigation.
My lords.
I'm
No,
not sure.
I am absolutely not on that aspect at all. That is what I
No,
was.
no, no, not that.
or-
Other than that,
Yes.
challenging this fund
My lord.
grants
Yes.
on 14 and 15.
No, lords, I am not.
In case one of us was the party in the litigation as a lawyer, it would not be proper to,
That is
Take
my
up the
lord's entire
so
discussion.
we will
I
take it up tomorrow. Can we?
Can
You extend your stay. It's a beautiful weather here.
All right. no. All right. no.
Loss,
You find it out.
I'll find out.
Thanks.
Mr.
Mahmood Pracha.
Pracha. One thing you will have to do is also that where the FR has been filed, I mean registered,
Yes.
you will have to segregate it. The
All right.
specific cases. You are saying that so many FIRs you have lodged.
My lords. My
Some of them have been registered.
lords.
So that in that case, we cannot, at this stage, cannot go into all those things.
As my lord.
Where the case FR have been registered, that we cannot go into at this stage.
Let's- Additionally, I had requested for monitoring of that FR also. So that part can be retained, lords, because
So
I am not
when-
saying,
Where
because
you are-
2000, sorry.
you are claiming that the constitution, there is a violation of constitutional provision. At the same time, you are not seeking to violate the provisions of the law. When the efforts have been registered and the investigation is going on, cannot assert their power.
Let's.
It's it will be guided by the provisions of law.
What I was most respectfully submitting was that there are two aspects to my PRN. One is the constitutional and legal violations, which is one
We'll
half.
take it up tomorrow, all right? Because if we cannot take it up, let us be sure about it. We request you
Okay,
find it.
I'll-
Could I request
This
my
is-
lords to take it as item number 1 tomorrow also, if your lordship please?
No, not necessary.
In that case, I can rush back tomorrow.
Let's this matter tomorrow. We'll just select.
Can we argue on VC?
No, tomorrow at the.
No, what I was requesting was, will your lordship permit me to argue on?
We cannot deny that privilege, but then it's difficult out
All
here.
right, all right.
Because maybe network. And other things. It's better you can physically argue it.
Yeah, please, madam.
Yes.
Earlier, this writ petitions was filed before London single bench. but
Yes.
It was withdrawn, to file a press matter. That's what has not been mentioned in this writ petition. sir.
You are challenging which rule, which provision?
My lord, basically, what happened for non-functional upgradations, if the particular RR is not amended, I will not be entitled, my lords.
How can we direct to amend the law?
No, there is, my lord, as per the provisions of OM 2009 and 11, they says appropriate amendment may be taken up, my lord. So on that ground only, I am coming before this court to grant me non-functional upgradations.
See, rule doesn't permit to grant you a non-functional upgradation. You are aggrieved by that, with that rule.
Rules permits, my lords, but
If
that's
rules
rule,
permits, then you,
but
this
my,
will be placed before the division, a single bench.
no, but amendment is required for that purpose.
Law is very clear. You cannot direct to amend or enact a law or rules. You cannot.
No, my lord. Direction may be given to consider the grievances of petitioner and to consider for the amendment, my lord.
In that case, the
Otherwise, my lord, it says,
your petition will not lie before the division bench.
yes, ma'am. Because we had
Are you
discussed,
challenging the rule?
yes, my lord,
Then
rules,
you are saying that unless the rule is amended.
yes. I will not be,
So it's basically you are seeking a direction to amend the rule.
yes, my lord.
Can you do that?
That can, if my rights is curtailed by the rules, this court can, my lord, direct.
The rule is not made for only one person, one employee.
Yes, my lord, that's true, my lord.
It's for all.
And this guidance is also for
You
the,
may have some personal hardship, but that cannot be a ground for
No.
challenge the rule.
no, my lord, that is for the organized group A services. That is for the organized group A services, my lord.
How you are aggrieved?
Because rules, unless rules is amended, I will not be entitled, my lord.
We cannot direct them to amend it. You will have to challenge the rule on certain parameters of the virus of the rule. Then only we can intervene. Simply because it's not supporting you.
Yes, ma'am.
We just cannot tell, direct them to amend the rule.
Because, my lord, as per the
Because
guidelines,
because law is very clear. It's not as
unless rule
it's
is
not
amended,
as
my
simple
lord,
as you try to project.
unless rule
You
is
are
amended,
challenging the virus of the rule.
my lord, unless rule is amended, there's provisions, the office memorandum 2009 will not be
Yes.
implemented, my lord. It cannot be
Can you check up
implemented.
the law?
Rule can be, this court can direct the amendments of the rule. If that rules violate, that rules curtail the rights of the petitioners, my lord.
That in that case will intervene, but you are saying that direct them to amend the rule and to make you grant you a non-functional upgradation. This cannot be simply like that. Take up the law and come.
Then, my lord, matter may be passed of the over person other days. I'll come with some authority, my lord. Rule amendments of the rules can be direct. to This court, ma'am.
We may grant you a time to go through the judgment.
Yes, ma'am.
After going through the judgment, you may have to withdraw the writ petition.
If that's so, I'll do that, my lord. If that's so, I'll do that, my lord. I'll withdraw if that's so, my lord.
We'll take it up on Friday.
Right.
To go through those judgments.
Yes, ma'am.
If any difficulty, you also, any difficulty, you may seek our help also. Learned Advocate General is there.
Yes. I'll try.
On the prayer of Mr. K. Thari, Learned Counsel for the petitioner, list this matter on 4th 04/10/2020.
Obliged.
We have filed the affidavit,
Yeah.
annexing there with the draft rules.
Okay.
to-
Definitely.
It was filed on 25th.
For you, any statement that is likely to be completed within which?
Para 4.
Yes. Six months.
6 months. I will, at my level, I'll try to expedite it, but,
This 1978 Act.
but ultimately, thanks to the petitioner, something has happened.
We'll dispose of the matter.
Lordship may be taken up on 3 of this.
No, no, nothing.
Says learned.
The prayer is virtually,
It's a PL. You are seeking for framing of the rules. As per section 6 of the Freedom of Religion Act. Now they have filed an affidavit annexing the, have you seen the affidavit? Draft rules. And they are seeking 6 months time. I think it's reasonable. We'll close it. Heard, Mr.
S. Yerang, Lordship.
Mr.
S. Yerang.
S. Yura, learned counsel for the petitioner. And also heard Mr. I. Chaudhary, learned advocate general. By filing this public interest litigation, the petitioner, essentially the petitioner is aggrieved to the effect that the state authorities have not framed the required rules as mandated under section 8 of the Arunachal Pradesh Freedom of Religion Act 1978, even after lapse of 45 years of coming into effect of the said act. Mr. The state, by filing the additional affidavit, has stated that the draft rules has been submitted to the government for further scrutiny and for obtaining vetting from the law department. Mr. Next paragraph. Learned Advocate General, Mr. I. Chaudhary, submits that the process for completion of the rules, a framing of rules, process of, no, the
Lordship may say process of
framing of rules,
finalization.
no, for the finalization of the rules would take at least another 6 months' time. Mr. Next paragraph. Having considered the submissions of the London Advocate General and on the perusal of the affidavit and the draft rules, you are of the view that no useful purpose would be served by keeping this public interest litigation. Accordingly, the public interest, accordingly, this present petition is closed. It is expected that the draft rules would be finalized within a period of 6 months from today.
I will at my level, I'll.
Thank you.
Oblige. Lordship may.
Record also confirmed. What is the offense? Sir? Yes, sir.
Yes, Lordship, the service on the respondent is complete.
Hmm.
They are yet to appear. Yes. Legal 8, legal counsel may be appointed.
Directed to institute upon the legal aid. Heard Mr.
Thank.
Learned Counsel for the appellant and Mr. G. Tado, learned additional PP for the state office note dated 26/09/2024. Discloses that the service report, service in respect of respondent number 2 has duly been served. No, not service, notice. On respondent number 2 has duly been served. Therefore, service is complete. However, no, not however, Mr. The registry to non-APS code respondent number 2. Mr. In view of the above, the registry to appoint legal aid counsel.
Oblige.
Record. What about the record? You write the secretary, registry come. Registry of the secretary, legal, High Court Legal Aid. Legal Services Committee to appoint her legal aid counsel. For respondent number 2. Whatever the
And meanwhile,
whatever the records,
paperwork has to be prepared.
record has been received.
Yes, Lordship.
Record is received.
Yes, paperwork, LCR has been received. Paperwork has to be prepared in meantime.
LCR is there. Yes. Further, the registry to prepare paper book.
Yes.
List after preparation of the paper book.
Filing of the obligation.
May I please, Your Lordship?
on behalf of the convicted person, petitioner, due to some personal difficulties, I am unable to prepare this case, Your Honor, and give some more time
Why
to.
have not mentioned?
I came late, Your Honor, due to some traffic problem. I came late, Your Honor.
There's a traffic congestion in UPR road also.
Actually, I'm some problem at Itanaga, so if possible, after 4 weeks.
When do we want?
After 4 weeks, if possible.
Mr. M. Bagara,
M. Bagara,
learned counsel, your legal aid counsel,
legal aid counsel.
legal aid counsel submits that due to his personal difficulty, he could not prepare the matter for argument. Therefore, refresh for adjournment to further 4 weeks, adjournment for 4 weeks. MS TG, learned registered PP is present. Prayer of the learned legal aid counsel is accepted. List this matter after 4 weeks.
Deep oblige.
বেশি ইয়ার পরে হবো তো ইয়ার পরে হবো আজকাল কোটোর পরে হয়তো
Can it be after the vacation?
Retrospective.
Yes, I'm in a bit of a fix, which judgment to rely now. 1 year lordship is dismissed, 1 year lordship is allowed. But this is a different
It
case.
will be again difficult for this court to.
Yes, but this is factually a bit different in the sense that there is nobody else.
Yeah.
I'm the lone person. I was given officiating promotion in the substantive vacancy. In fact, on the last, I'm praying this adjournment because of the last occasion, Justice Nair told me there is a judgment by Honorable Justice Ansari on this point, but I have not been able to lay my hands on it. I've been searching for it.
But law is very clear.
Yes, yes.
You don't have the right. to
Yeah, I don't have the
Claim
right.
for retrospective.
Yes.
But this court view is in certain given.
That's
cases,
what I will try to solve from
depend on
the,
the facts and
yes,
circumstances.
from the facts of the case, because they tried to do the DPC because of, it is not a case that they don't want to give.
The last 2003 or 2023,
Yes.
the judgment of the Honorable Supreme Court.
They-
This
they-
is
they-
Hima Kohli or
Yes,
That came up, yes.
It's a very recent one also. That is there. But those are facts, these are, in the sense, there were 50-50 things were there. Basically not truth.
what do you want?
After the break.
Mr. Deepang, learned counsel for the petitioner.
After break means
Press for adjournment of this matter to, for 4 weeks. Mr. Trial yellow, list this matter after 4 weeks. Mr.
4 weeks.
4 weeks. 4 weeks or 3 weeks?
Any day
Said,
after,
after
the
break,
vacation,
this would be
after the
one-
puja break.
Then three
Three
weeks.
weeks, after 3 weeks.
3 weeks, then 3 weeks, huh? Mr. Arachana Lan, Commission Advocate General is present. Huh?
Our Lordship, I would like to mention item number 1, Your Lordship. May I
One.
Kindly take up this matter after vacation, Your Lordship, after puja break.
There was
Why?
some urgency in this, but Mr. Ratan is not here. That is a difficulty. I
But
thought-
this is your increments
Yes,
have been curtailed
yes, 16.
for those period.
Yes, 16, but
Which is-
the
which is-
disciplinary authority,
This is considered to be not spent on duty
yes, yes,
from your absent period.
yes. But how can they do that? The disciplinary authority, the appellate authority has registered into service, withholding only 2 increments with cumulative effect. Now the superintendent of police is a
But
controlling
at the
officer.
same time, it says that your period of absence
Yes,
is
cannot
cannot be
be
treated as
not spent on duty, but that would not mean, my lord, that the increments can be, this is only for the purpose of back wages and all. There's a judgment of the Delhi High Court on this point. That can only be considered because FR 56 is also clear.
it's-
Periods not spent on
it's-
duty. What is the purpose for that putting it?
Yes, it's debatable.
Yes.
It's debatable.
My
Not- It's debatable.
Yes,
It's not that as simple as that.
but my lord, the period is not spent on duty. That term is used in terms of FR 56 in a disciplinary proceeding.
For either of the parties,
Yes,
petitioner as well as the respondent.
Yes.
It's not that as simple.
it's not as simple, but through my understanding, where FR, what is the purpose of FR 56? FR 56 is very clear. It is for this purpose, there is, and there is, I have not been able to lay my hands on any judgment of the Supreme Court on this point because it is only in Arunachal Pradesh these things happens. But there is a judgment of the Honorable Supreme Delhi High Court that says period not spent on duty does not mean that you will not be considered for further promotion and all. It will be only for the purpose of back wages. There is the view of the Delhi High Court. We'll see when it comes.
On the prayer of MS Arbas at London State Council, this matter after 3 weeks.
Push up.
Mr. Deepang, London Council petitioner is present.
May my lordship, I beg to mention item number 14 and 15. my lordship.
14 and 15.
This matter may be listed after vacation. I had taken consent.
On the prayer of MS.
They are supposed to file the affidavit in this matter.
Will be filing my lordship.
When,
What is the matter?
well, that the no confidence motion has been halted by the district collector. Anyways.
Okay. 14 and 15.
Yes,
You have no objection. You have no objection.
I have no objection. Let them file the affidavit, but they should.
What is IA? IA is for what? 14 is IA.
Yes,
IA is for what?
for. My brief is there.
Because it's listed for orders, so.
Yeah.
Service reports awaited. Had Mr. Titi Tara, learned counsel for the petition, applicant, public petitioner, and also had MS K. Wang, learned state counsel for the response. Office note dated 27/09/2024 discloses that service report in respect of respondent number 4 and 5 are still awaiting. List after 2 weeks
After,
awaiting service reports.
correct. Great.
Your Lordship, I beg to mention item number 22. I am appearing on behalf of Vedanto.
Item 22,
Yes, Lordship. I am appearing on behalf of Vedanto Kosik.
22.
Yes, your
What is to be done is listed for orders.
uh,
We'll see
leading counsel is from Guwahati, he is engaged in the principal bench today.
what is to be done.
You also better.
22,
Otherwise, also, we are supposed to file a PDB. PDB is almost ready, so.
service, any private respondent?
Yes,
You are
well,
for private respondent.
they were
Respondent number five,
key
private
creators, man.
respondent number 5. Private respondent number 5.
How many private respondent?
Two.
Who else are applying? Six is still awaited. Service report is still awaited. On respond number 6. You are 5 or 6?
5.
Which 6? TNT Enterprise, you are 4? Tenzing Construction,
You also have Keveter. Respondent number 5, Keveter.
respond number 5. Who is respond number 5?
Tenzing Enterprise, man. Private respondent. He was a caveator, man. He was caveator. in this.
Okay, whatever 6. 6
Well,
is
we
not
have taken-
complete. The service has not been served. Respond number
No,
6.
we have taken steps, Maladu.
Yes, you have taken, but report is still awaited.
Yes. Maladu, yes.
So we'll wait for some time. Since the service is not complete.
Maladu, this your lordship is aware, it's an urgent matter already, Maladu.
What to do?
No, Maladu,
You take dusty.
I'm praying, Maladu.
You take dusty.
Yes, that's why I'm praying that I may be allowed to take
Okay.
dusty also, Maladu.
Had Mr. Peter learned counsel for the petitioner. And also had Mr. G. Tarak and
Sita Jo.
Mr. So-and-so for state respondent and respondent number 5. Office note dated 27/9/09/24 reflects that service report in respect to respondent number 6 is still awaited. Mr. Peter is permitted to take steps
Yes.
for service of notice upon response 6 by dusty mode.
Mhm.
And they are prepared to file an affidavit
Yes.
to that effect, Mr. In the meantime, Mr. G. Tarak, learned, in the meantime, no, not in the way. The respondents are directed to file their reply, a response. When? After vacation.
Well, by default, otherwise, lordship is available. I would have thought it should be listed on Thursday.
There is one subject to outcome.
The problem is they have not also filed affidavit. Why you are not filing an affidavit?
So many petitions, we are filing 2 or 3 petitions today.
So if there are so many writ petition, you are not filing affidavit.
No, we are filing, almost ready.
Then we'll take it on Friday.
Friday. Friday.
Anyway, after
Malad-
vacation, immediately after the vacation. I know they will not be able to file by Friday. And Mr. Tarak would like to enjoy the last day of the court.
Friday, till Friday. Friday.
If you file on Friday,
Yes.
In
when
the
he,
meantime, we can reply immediately after. Yeah, right. We can dispose of.
so we'll make it after vacation only.
Immediately, Maladu, after vacation.
Considering the respondents to file response, thereafter you just, Mr. G. Tarak, learned standing counsel for RWD, undertakes to file the affidavit on behalf of the state by 4th, by 04/10/2024. Mr. Christopher, let the matter be listed immediately after
On
Reopening.
22nd, Maladu,
on 22nd,
October
10/2024.
of like.
My Lordship, Lordship, I'm
Yes.
going to mention item number 28, Lordship.
28.
Lordship, I'm on behalf of Sri Ajin Apang, Senior Advocate, Lordship. Due to some medical emergency, he has left for Guwahati today morning only, Lordship.
Is it
Lordship,
serious?
Lordship, family medical issue, Lordship.
You have taken the consent?
Yes, Lordship, I have taken.
Okay. On the consent of learned counsel for the petitioner, Mr. T. Tagu. Mr. What's your name?
K. Mena, Lordship.
K.
Mena, Lordship,
K.
M.E.N.
Mena, learned counsel appearing for Mr. A. Apang, learned senior counsel for the respondent. For the respondent APPSC, let this matter be listed after 4
Lordship,
weeks.
after break, after puja break.
After puja vacation. Huh?
Obliged.
No affidavit.
Lordship, on behalf of respondent number 1 and 2, Your Lordship, it needs some time, Your Lordship. We have received the instructions, Your Lordship. After break, Your Lordship, maybe.
Heard Mr. Aibab, learned counsel for the petitioner. Next madam, MS Arbasad, learned state counsel submitted. She has received the instruction. And received the instruction and pressed for some time to file the affidavit. Praise the Lord. List this matter after.
Break, Lordship.
Yes.
This is regarding.
The
change of
records,
date of birth.
records.
Records, Lordship, they have already annexed the
Yes.
documents.
So you consider it.
Yes, we can consider, Lordship, because
it?
in the school transfer certificate also date of birth is
So you
currently
consider it?
recorded.
Because what is the, you said her case cannot be considered because there is a rule,
Yes, yes, there is.
guidelines and rules.
Yes, but if you Lordship.
Is a rules? What is that
There,
rule?
they have annexed the rule also.
Where is the rule?
Last 28 page number,
28.
yes.
Where is the relevant one?
69.3 Lordship, the correction in date of birth. The correction as per the school records. Correction is to correct the typographical and other errors to make the certificate consistent with the school records can be made, provided that the correction in the school records should have been made after the submission of the application form for admission to examination to the board. Such correction in date of birth of a candidate in case of genuine clerical errors will be made under orders of the chairman, where it is established to the satisfaction of the chairman that a wrong entry was made erroneously in the list of candidate. That is list of LOC. The list of candidate stroke application form of the candidate for the examination. In this present case, Lordship, what happened? The list of candidate, the school principal, I think he has wrongly quoted the date of birth.
There's a provision that if the courts direct,
Yes.
you can correct it.
Yes, last
This is what rule?
B Lordship correction as
What
per
is the,
court order.
what is the name of this rule?
The CBSE bylaws also.
It's a bylaws only.
Bylaws.
This is notification.
There is also notification.
Recommendation, the examination of
notification,
this
Lordship.
meeting held on the duly approved the government body's meeting.
Earlier it was 1 year, now it is 5 years.
Is it bylaw?
No, within the bylaws, it is a notification. It was issued on 1/2/18. Because
So what is your submission in that case?
Lordship, in the last paragraph, last page, Lordship, no, page 28, last paragraph. The
Right,
correction as per court's order. The application regarding correction in date of birth of the candidate will be considered, provided that the correction has been admitted by the court of law. In cases of correction in date of birth in documents after the court orders caption will be mentioned on the document correction allowed in the date of birth from to so and so as per court order dated. Lordship, if your lordship direct, then correction can be made, lordship, because it is, I think all the record shows his date of birth is 2000.
Hmm.
It is 29/6/2000.
So I'll
But-
record your submission.
Yes,
If the courts direct, it can be corrected, though
Yes.
it has to be corrected within a
Uh,
period of
and-
1 year.
Yes, one thing is there, lordship, the principal should forward all the documents.
Yes, we'll see.
It should go.
I think they have already forwarded.
It was rejected because of this 2018 notification.
Where is this, your application, forwarding application?
He has not annexed.
Page number 18.
18.
Yes.
Regional
annex of-
office so and so. Yes, it has been forwarded. Correction in the date of birth in respect of Miss Purpose so and so.
That was, yes. Principal has, but
Forwarded.
yes, already it's fresh, lordship.
We'll ask the principal to forward a fresh
Yes.
application
fresh-
along
fresh.
with all the relevant
Yes,
records.
all the documents,
All the
getting all
document,
the.
annexing all documents.
Yes.
Okay. Heard Mr. What's your name?
El Kagum,
Learned counsel for the petitioner. And also have MS
Arbora,
Arbora, learned
1 and 2 lordship,
standing counsel,
CBS.
standing counsel, CBSE, comma, respondent number. No. Learned standing counsel, CBSE, for respondents list of. By filing this application, the petitioner has first sought for a direction to the respondent CBSE to correct the date of birth of class 10 certificate on the ground that no, not on the list of, huh? Next paragraph. It is projected that the petitioner was admitted in the government secondary school, newspaper in the year 2006 and passed class 8 standard from the said school in the year 2010. As per the admission record and the school leaving certificate, the petitioner's date of birth was correct. It was recorded as is recorded as 29/06/2000. Please stop. Which is also fortified by the birth certificate issued by the Department of Economics and Aesthetics Office at SEPA, wherein it is recorded the birth certificate, date of birth of the petitioner is 29/06/2000. Next paragraph. The petitioner thereafter admitted in the government higher secondary school, SEPA. In class 9, wherein the correct date of birth i.e. 29/06/2000 was also recorded. It is contended that while filling the forms for registration in class 10, he or she had correctly fill up the forms as required by the CBSE, respondent CBSE. Please stop. In the year 2012, the petitioner has passed the class 10 standard. On receipt of the certificate, it is found that the date of birth of the petitioner is wrongly recorded as 29/06/1994 instead of 29/06/2000. Thereafter, the petitioner has informed the school authority for correction of the mistake, the correction of wrong recording of date of birth by the respondents. List of in class 12, the date of birth is recorded correctly as 29/06/2000. However, in view of the wrong recording of her date of birth is 29/06/1994 in class 10 certificate, the petitioner is facing hardship in list of next the petitioner again approached the headmaster of the government higher secondary school SEPA for correction of the date of birth in class 10. And accordingly, the principal, page 18.
Page 18.
Principal by letter dated 16/08/2019 has forwarded the case of the petitioner to the regional officer, Central Board of Secondary Education, Guwahati, clearly stating that due to a collective error, the date of birth of the petitioner was wrongly entered as 29/06/1994 in place of 29/06/2000 and requested for correction of the same. However, the respondents has refused to correct the date of birth of the petitioner on the ground that as per the notification dated, as per the bylaws dated 01/02/2018, any correction of the date of birth has to be made within 1 year.
No, earlier it was 1 year, later it was 5 years,
Now 5 years.
now 5 years.
Within 5 years.
Within 5 years, was it,
Within 5 years from the date of declaration of the
Paragraph four.
result. List of. When was the class 10? When did you pass the?
12.
When did
2012.
2012?
12,
Yes.
limitation is not there.
Anyway. So, 12, 7 years. You have applied on it's after 7 years only.
His application, he is not annexed, it's only the order of the principal 19, yes.
Anyway. Third, the learned counsel for the parties. Next page. It is. Sorry. Notice that the, no, admittedly, the birth certificate as well as the school, admittedly, as per the birth certificate issued by the Department of Economics and Statistics, dated 16/6/2005, and the entries in the school admission register as well as transfer of the school living certificate. The date of birth of the petitioner is recorded as 29/06/2000. Mr. Records reveals that. Where is that class 10 certificate?
Page 17.
17.
Yes.
Mr. The certificate of class 10 reveals that the date of birth of the petitioner is recorded as 29/06/1994. Mr. The petitioner, next paragraph, having found the incorrect recording of her date of birth, has approached the concerned authority, i.e., headmaster and principal, for forwarding of correction of the date of birth. Please, Mr. The principal, by order dated 16/08, by letter dated 16/08/2019, has forwarded the same to the concerned authorities. Mr. However, in view of the bylaws, the respondent authorities, in view of the bylaws providing for correction of date of birth to be made within 5 years of the date of declaration of the result, same could not be considered and corrected. Next page. The relevant bylaw, the relevant provisions of bylaws of the CBSE dated 01/02/2018 is reproduced herein below. Page 28, huh? 69.3 correction in date of birth, huh? Then you quote this AB, huh? 29, 28 and 29. Right side, huh? You quote this. Next page. Having considered that the no. On consideration of the records, come on. It is noticed that the date of birth of the petitioner is recorded as 29 2000 in all the certificates, including the school admission register and the transfer living certificate issued by the school, issued by the concerned school. Mr. The petitioner, the headmaster, the principal of government higher secondary school, SEPA, has also forwarded the case of the petitioner for correction of date of birth, stating that due to a clerical error, the date of birth of the petitioner has been wrongly entered as 1994. Mr. On perusal of the letter of the principal from government higher secondary school, SEPA, it is seen that same was forwarded on 16/08/2019. Next paragraph. Before that paragraph, you add this after quoting, just before this last paragraph, you after quoting this, you just add one more paragraph. On bare perusal of the pursuit, bare perusal above provisions of the bylaws, it is seen that the correction of date of birth, a candidate has to apply. The case can be entertained by the respondents only within 5 years of the date of declaration of the result. Mr. However, it is also provided, it also provides that application regarding correction in the date of birth of candidate will be considered provided the what does it mean? No, provided that the correction have been admitted by the court of law. In case of correction in the date of birth in documents after the court orders, certain caption will have to be mentioned on the documents. Mr. Then you last paragraph. What is the last line? Yes. Please to one. Does undisputably, though the petitioner has approached the concerned school authorities within time, however, the forwarding was the principal of the school appears to have forwarded after the lapse of more than the lapse of 7 years. Mr. Next paragraph. As noted above, since the bylaws provides for an correction of the date of birth will be considered provided the correction have been adjudicated by the court of law. Having considered above, and having considered that the school records, the records no, having considered that the school admission register as well as the birth certificate issued by the Department of Economics. What is that? Statistics. Department of Economics and Statistics, Government of Arunachal Pradesh, issued way back, issued on 16/06/2005. And considering that the bylaws provide for consideration if the courts of law admitted the same, coupled with the fair submissions of MS Arbora, learned counsel for the respondents, I deem it appropriate to allow this writ petition. Allow this writ petition, and to direct the respondent CBSE to correct the date of birth as 29/09/2000 in the class 10 certificate. Accordingly, the respondents are directed to consider and correct the date of birth
Consider
of the petitioner as 29/06/2000 in place of 29/06/1994 in a class 10 certificate of the petitioner. The petitioner shall submit all the required documents before the principal of school, principal of government higher secondary school, SEPA.
Yes.
On police staff. The principal government higher secondary school, SEPA, shall forward the same, forward all the required documents that may be submitted by the petitioner to the respondent CBSE for consideration and correction as directed herein. Within a period of, you just mentioned one thing, directed to consider and correct, within a period of 6 months, 4 months.
4 months.
4 months from the date of receipt of the
From the receipt of
forwarding and the
All
documents,
documents.
somewhere in between. The writ petition is still allowed in disposal.
Mobilize.
My lord, in this case also the made difference. When I am newly engaged in this case, I am appearing and place on behalf of the private respondent. I think number 4, respondent number 6. 6. We pray for some time to file counter.
It's okay, but no, appears they have not complied with their terms and conditions. Government.
Now we are filing, actually, my lord, in fact, 344 earlier mentioned, I am filing today, actually.
So this one,
This will file Friday.
Friday.
It's almost.
My lord, otherwise, my lord, we are not
praying anything against the private respondents here in Marat. If your lordship will see the matter.
Then why you have
I will have to respond. No, no. If the
Party.
Here is allegation.
the what we are praying is allow us also to be participate in that. No, we have been allowed it, yes, in the prize bid matter.
price bid?
Yes, that's all. Then authority may take further decisions.
Sir,
madam.
for that, we have
In any
to
case, I have to
decide whether we
Yeah.
have correctly reject your
Yes, yes.
bid or not, that technical bid or that we'll have to decide.
What you
That's
find
the
by
reason we're expecting you to find the counter affidavit.
Otherwise, it's almost ready. On Friday, we'll find.
What is your ground?
Ground
I
is
mean, what
that,
is your stand, not ground?
my lord, ground is that the truck water tanker which they have submitted, the document which they furnish is fake.
Right.
Yes, we have confirmed from the dealers which they have issued the invoice.
Why you have submitted a fake document?
No, that we will see. One of the first, let's see what kind of affidavit they are
So-
filing.
Yes,
Otherwise,
Mr.
yes, sir.
Peter, learned counsel for the petitioner. The respondents, no, Mr. Deepang, learned counsel entered appearance on behalf of the respondent number 6 and sought for, and has sought for the time to file a response to the writ petition. Mr. G. Tarak, learned standing counsel RWD, submits that. No, not,
For 5 also.
RWD undertakes to
5
file the affidavit by 04/10/2024. In view of the submissions and the prayer made by the respondents. They are granted, in view of the prayer made by the respondents. Let this matter be listed after,
Yes, but the same date, Melon.
after 2 weeks, after 3 weeks. By granting the respondents to file their response.
Malad, in this, though respondent number 6 was KVA here, Malad. In respondent number 5, Malad, no order was passed. So we have to take steps, Malad. Dusty also, your lordship may allow us.
Next page, next. Inadvertently, since there was no notice was issued to the respondent number 5.
Yes.
Let the notice be issued to the respondent number 5. Mr. Peter, counsel for the petition, take steps to service of notice upon so and so registered person. As well as Dusty Mount
Yes.
within 2 days from today.
Same Malad, 22nd, Malad.
On 22nd. Listed.
5 affidavits.
22nd, let it be on 24 or 25. If your lordship is giving a date.
You agree to that?
My lord, I said 3 weeks.
Malad, because we lordship is maybe
3 weeks will be immediately after the,
we have to pursue again, Malad, for that. That's why.
to make it 23 or 24.
24,
Then
then 24 him only, because
Yes,
I will be able to
25.
define that 21 or 22 only, he may have to reply also. 24, man.
24.
This case will not able to file on Friday, but within 2 weeks we'll file.
Okay.
Item
Then 2
5,
weeks,
item 5, respondent number 7.
respond number 7.
If-
What about others?
Respondent number 6. Same Malad, there also we have to take Malad, Dusty service.
6.
So,
6 and 7 are the private respondents.
Yes, 6.
I am appearing
Then
for 7.
you just write.
For 6, we will take Dusty service, Malad.
And Mr. Peter Polan, counsel to the petitioner. Mr. Deepangin has same order. Enters appearance on behalf of respondent number 7, not 6, huh? And phrase for sometime to file response. Mr. G. Tarak has also prayed for learned counsel, learned standing counsel RW has also prayed for 2 weeks time to file counter affidavit. Prayers of the respondents are allowed and granted. Then you write, since inadvertently no notice was issued to them. Respondent number 6 Let notice be issued to the resolution number 6. Mr. Peter Pochema to take his stage for resolution.
Dusty, let's.
As well as Dusty Motor. For response number 6, here.
My lord, in this contempt, my lord, the respondents have filed affidavit, my lord. And nobody is taking the, your lordship, last time directed that they should file the compliance report, my lord.
Yes.
By today.
My lord,
Hmm.
your lordship, we have forwarded this file, my lord, demanding necessary funds, my lord. But in spite of our earnest attempt, my lord, the government is not clearing, my lord. So we had to.
Are you not a government?
My
We are
lord?
not concerned.
Yes, my lord. We
Are
understand.
you somewhere sitting in the
No, my lord. We understand our position, my lord. Please, my lord,
Bulgaria or Turkey?
my lord, please let me read para 3, my lord. Para
Yes.
3 of my affidavit. my
Not
lord.
para 3. Let us read the order of this court first.
This court order, my lord, it is in page number.
In view of the above, the respondent 1, 2, 3 are directed to pay the above. What respondent number 1, 2, and 3?
My lord, secretary, chief secretary and secretary, my lord, and director.
Yes. Whom you are blaming? You are appearing for whom? All of them.
No, 1 and 2, my lord.
Who is 1 and 2?
Oh, my lord, commission, secretary civil supply, and
Yes.
director,
Secretary, you cannot blame the government. You are representing the government.
my lord.
You assure us today, within 2 weeks.
My lord,
Of course, we cannot
my lord,
modify the order,
no, my lord.
but they're taking the lenient view.
We are not praying for the modification of order. We understand our position, my lord, and it is admitted, my lord.
So you don't say that you have applied for the fund and the government is sitting over the matter. It is your duty. You are the secretary.
My lord, we are pursuing, my lord. My lord, please give us 6 month time, my lord.
No, 6 months cannot.
More than 1
You
year.
have not filed an application for that also.
My lord, please.
Within 3 months from the date of receipt of certified
Yes.
copy. When did you?
It was received, my lord,
On September, lordship.
September.
my
September.
lord, page 15, page 15. So,
September of
2023,
27/9/2023, my lord.
23.
Yeah, my lord,
Today is what?
September 2024.
1 year.
my lord.
1 year.
Yes, my lord. So in that time, my lord, file was moved by us. First file was moved by us, my lord. For this
I think Mr.
placing of necessary fund,
Mr. Jamo, it's a high time.
my lord.
We'll have to send someone.
And my
Let them
lord,
face the music.
recently also.
You just cannot you just cannot take it lightly. You have not filed an appeal. You have not filed an application for seeking time.
Your lordship, there is no question of filing appeal, my lord. We have admitted it, my lord.
Then-
We have accepted
Then
your lordship this. Direction we understand, we are obligated to this, pay it, my lord. This, we are praying for some time, my lord. Some more time, my lord.
you have not filed an application for seeking extension of time for compliance.
My lord, in fact, we have made this here, my lord, in this
Yep.
petition, my lord.
Huh?
In this petition, we have made it, my lord.
In your application, affidavit.
Affidavit, my lord. May I take your lordship to page number 21, paragraph 8, my lord?
Paragraph? Para,
Paragraph 8, my lord. Oh, no, 10, my lord. Paragraph 10, my lord. Paragraph 10. Paragraph 10. That therefore the humble deponent most respectfully pray that your lordship may be pleased to grant a moratorium for payment of the bill to the petitioner for further 6 months from today, so as to enable the humble deponent and the Department of Food and Civil Supply, Government of Arunachal Pradesh, to pursue the matter to the government and for the complete compliance of the order passed by this honorable court, for which this humble deponent shall be grateful, my lord. Your lordship, our position, my lord, our position, we have this brought out clearly in our Paragraph 3, my lord. It is the position, that's why. It is not that we are defying the order of this honorable court, my lord.
You have defined already. It's been 1 year.
My lord, in fact, please come to our this annexure 1, my lord. This file. requisition
Whatever
of
you
fund-
want to do, you do it. We
Right.
have given you 3 months time. Now it's been after 3 months. We have granted you 3 months time. Now it's more than 1 year. 1 year has elapsed. What have you done? What have you done? You are the secretary of the department. Are you so helpless? Are you so helpless?
My
We'll
lord.
direct you to replace.
My lord, in fact, it is sometime.
What sometime? Nothing. It's a contempt proceedings. Mind you.
It might. Your lordship, then at least 4 months time may be given, my lord. Since we are running after it, my lord, we understand our position. We are obligated to
You
pay,
must know, you must understand your obligation also
My-
and the duty.
my lord. We have processed 2 files, my lord, earnestly demanding
We're
funds,
not interested. We're not interested.
my lord.
Place the complaints report on the next date.
Your lordship.
Another contempt.
So, my lord,
60609/2024.
my lord, that's why, my lord. Out of helplessness, my lord, we had to initiate another.
How are so helpless? You are a secretary of the government, secretary to the government.
My lord, in fact, it is a financial matter.
That's,
Funds are not directly.
sir, let us not lecture on the duties and responsibilities of the secretary of the department.
My lord,
If he's so incompetent,
my lord, actually, funds are not directly placed under us such huge amount, my lord.
don't tell us that. That's better, you know.
My lord,
We're on the contempt proceedings.
my lord, kindly grant us some time, my lord. We are here for 6 months actually. We want to comply it, my lord. We want to comply it. Full compliance we want to give. But
You have to,
my lord,
or else you have to praise the music.
my lord. And
You are
problem,
not doing some charity.
my lord. Problem here is, my lord, a sort of professional hazard, my lord. We are facing here, my lord. Because we are trying.
So we'll call him, we'll see him tomorrow, we'll ask him tomorrow.
My lord, at least some time may be granted, my lord. Some time may be granted, my lord. We are pursuing it.
We'll request him to appear tomorrow personally. And also request the SP as well as the magistrate.
My lord, it's very hard, my lord.
What hurts? You have committed another contempt. This court has directed you place the compliance order. Where is that compliance order?
There was no compliance order, my lord, because there was no money.
Then you are admitting. So
There was
there's
no
nothing
money
else.
placed to us, my
We'll
lord.
initiate now.
Our, my lord, requisition,
Sir, we'll initiate now.
that will be through this, harsh, my lord.
When you are admitting that there is no compliance of the, there is no compliance of the court order, you are admitting we're initiating now, right now.
My lord, out of helplessness, my lord, we immediately,
Is the secretary is very, very strange, Mr. Jamo? The secretary to the government of Arunachal Pradesh is helpless. Would like to know him. Call him. We'll call him tomorrow. Or at 2 o'clock. Don't make such a submission. If he's so helpless, a secretary to the government,
Your lordship, sometime maybe granted, my lord. Actually, fund is not directly placed under that.
please,
We understand that limitation, my lord.
we're not ready to hear all these unnecessary excuses. First of all, try to understand it's a contempt proceedings. And then the secretary of the government is not doing charity. It's a constitutional obligation and the duties.
Your Lordship, sometime maybe granted, my. We understand it, my lord. Our position, we understand. Only submission we can make before your Lordship is seeking some time, my.
We're granting you 3 weeks time. Fully complied with it by taking a lenient view, or else you are initiating a contempt proceedings.
My lord, can it be at least in 2 months, my lord? We'll run after it, my. Please 2 months, give us 2 months, my lord. We'll run after
See,
it.
I am reminding you again and again, it's a contempt proceedings. You are not supposed to bargain.
Okay, my lord, we'll convey, my.
Not convey, or else or Mr. Peter, London Council for this. We're granting just 3 weeks.
But otherwise, your lordship see the reply para
Then we'll
6 and 8.
Then we will take a call.
They say, is have sent government's not doing
London
anything.
Council for the petitioner. Mr. T. Jamo, London Council for, no, Discord on 06/09/2024 has granted till 30 till today, 30/09/2024 for placing the complaints order. However, Mr. T. Jamo, London Council appearing for the alleged contempt submitted that due to what? Due to
Non-available.
due to what you have said?
My lord, non-placing of funds in our disposal, my.
Due to non-placing of, due to paucity of fund and also not and also fund not being made available to the Alice contempt, expresses inability to comply with inability to place the compliance order as directed by this court. Mr. On consideration of the submissions of the Learned Counsel for the Alice contempt, it is clear that it is prima facie, prima facie, the Alice contempt have in fact committed the contempt of the order of this court. Mr. However, taking the lenient view, the Alice contempt are granted further 3 weeks time to comply with the order of this court. Mr. On the next date fixed, if the respondent authority, Alice contempt no, this court will pass appropriate orders if the non-compliance persist. This after 3 weeks.
Contemners, madam. Two contemners.
Alice contemners. Take
Always,
care of
my-
it.
Always.
I think high
My
time.
lord, in fact,
It's a high time.
my lord, in fact, I would not have been landed in this position, my lord, had he been impleaded chief secretary, my lord. But he has not, deliberately, he left out the chief secretary, who was the main respondent here.
Sir, you
But
are the secretary of the secretary of the department.
Yeah, my. That we are.
You should know your rights and duties and obligations.
Obliged, my lord. Thank you.
Another contempt.
My lord, it's a contempt, my lord. It appears to be that they've misconceived, my lord. There's no contempt as such, my lord. In my respectful submission, my lord.
Where?
My lord, see
Where is
at
the
page,
order? Where is the order?
my lord, it's ordered at page 18, my lord.
Yes.
My lord,
Yes.
yes, my lord. The based on this, my lord, the earlier first status quo order passed on 7 August, my lord. Since it was coincidentally that's on the same day the relief order was issued, then court was of the view that it must be because of the communication gap. There's a coincide, my lord. Giving this benefit, my lord, the release order was directed not to be given effect to, my lord. Accordingly, basing on this, that order dated 12 August 2024, subsequently at page type copy as 20, the release order has been revoked, my lord. Now, now the petitioner has come up with this despite of revocation, my lord. At page 6, paragraph 5, they've said that despite of revocation, he has not been allowed to work and join there in Hai Long, my lord. Now, this as of now, my lord, as per instruction, my lord, it is not correct, my lord.
He has
Now-
been allowed.
Yes, he has been allowed. Even he has drawn the salary of August, my lord. We have a salary, even attendance also.
Yes, Mr.
Yes,
Should
yes.
rebound.
No, Your Lordship, the learned steering council is correct, Your Lordship. The revocation order was passed on 13, but it was given effect to on 24.
It's all right.
All right. Payment we have
Yes.
given all the August payment we have released, credited to his account.
No, Your Lordship, there is a, why I have filed this, because Your Lordship, there was, the status quo order was passed on 7th. And on the same day, the release order was passed.
Then
Your Lordship,
that has been revoked.
yes,
Subsequent page 18.
yes. And
in
Your
view of this
Lordship,
order
yes,
that has been considered by this court and it has been revoked. You have been allowed to continue.
yes.
Then,
But Your
then
Lordship,
what's
the-
the contempt?
yes, their purpose is to harass the petitioner, Your Lordship.
They file a damage.
Yes, the damage has already been
You
caused
file
to the
a
petitioner, Your
criminal
Lordship.
case against the officers.
Yes. And Your Lordship, here, if you see, Lordship,
Will
Uh,
impose you a cost
yes.
if you further make submission.
So if-
Okay. Will impose you a cost.
No, Your Lordship. Your Lordship, why this is a contempt, Your Lordship?
Heard Mr. Swenson, learned counsel for the petitioner. And also heard Mr. Tita, learned counsel for the Alice contempt. By filing this contempt petition, alleging willful disobedience and violation of the court's order dated 12/8/2024, passed in WPC 314/2024. What is this? Petitioner has alleged. Petitioner has alleged. Yes. Next week. This court. On, when was the first order? On 07/08/2024. As directed in WPC, same. Directed WPC 314/2020, directed to maintain it status quo in respect of the transfer of the petitioner. despite it is on 7, huh?
Yes, my lord. Yes, my lord.
On the same day, the petition was released. From which school?
From Hai Long, my lord.
It's okay. To enable her to join new place of posting at GUPS, Dingliang in the Anjo district. This stuff. The said release, despite the currency of status quo order, has been brought before this court by the petitioner. This stuff. While order dated 12/08/2024. While permitting the petitioner to bring such documents, bring documents on record, and considering that status quo was operating, it was provided that the release order dated 07/08/2024 shall not be given effect. Accordingly, the respondent authorities had revoked the order of release on 13/08/2024. Mr. It is submitted by the Learned Council for the Learned Standing Council Education Department that the petitioner has been allowed to continue in her
Yes, ma'am.
in her earlier place of posting at
Hai Long, my lord.
Helium
Hai Long Government School.
immediately after the receipt of the order of this court dated
12 August
12/8/2024. 2024. As the release order was passed on the same day when the earlier status quo order was passed by this court. Mr. He further submits that the petitioner is continuing in the same place of posting and regularly.
Yes. And pay has
and
also been.
She is being paid her regular salary
Salary.
from the same school. Considering the above, having considered, and considering, now having considered that the release order has been revoked immediately after the order of this court on 13/08/2024. I'm of the view that there is no contempt on the part of the at least contempt on the part of the respondents. Accordingly, contempt petition stands dismissed and closed.
Deeply obliged.
Item number 8 to 11.
Sir, in these items, number 8, 9, and 12, I am for the petitioner.
What is to be done today?
My lord, there are a couple of miscellaneous.
Yes, there is.
Couple of miscellaneous cases, your lordship should consider disposing of the miscellaneous cases. In item number 8, your lordship will find IA 84 of 2024. Now, this IA was filed by one of the parties seeking vacation of the interim order. But since last 3-4 dates, my lord, he is not, neither of the parties are appearing. So if your lordship may consider disposing of this IA because of non-representation.
Which one?
In item number 8, your lordship will find IA 84.
No, one by one.
Yes, I am going one by one, lordship.
Yes, first take up the item.
Item 8.
Item 8 is writ petition.
Yes, writ petition.
Okay.
So in this writ petition, one IA is filed, that is IA 84 of 2024.
Yes.
Now, this has not been praised for quite a long time. Last 4-5 dates, my lord, they are not appearing, not pressing it. So your lordship may consider disposing it off. This IA was filed by one of the private respondents.
There is a submission by London additional AG
Yes,
that he has the instruction the Advocate General will be appearing in these matters. Accordingly, it is prayed that these matters be listed in the next.
no, my lord.
Accordingly,
Then after that, I consulted with him, my lord. He's not appearing, my lord.
So.
Again, file
you are-
a
you are
re-endorsement,
making-
my lord.
Making a somersault.
No, my lord, he wanted to see the file actually.
Okay.
So there is a little bit miscommunication, my lord.
Yeah.
But I think, my lord, IA 84 your lordship can dispose of because it is not being praised for a long time.
It is listed for, it is IA is for what?
IA is for
Nobody-
vacating.
No, it is appearing for the applicant.
No, IA in
No.
the IA 84, my lord, it is for vacating the interim order.
Okay.
So pleadings were completed as far as this IA is concerned, but they are not pressing it. So therefore, I am saying that it can be disposed of.
It's okay. We'll just keep it like this.
Then then your lordship may next consider IA 123.
120. Yes.
123 is one IA filed by us
120. Yes.
seeking and
123.
seeking amendment of the writ petition in 1993. 93 of 2024.
Yes.
So that IA your lordship can allow because my learned friend said that they will not be opposing the prayer for amendment.
Okay.
So that IA 123 your lordship can allow.
You can allow in sort of the.
Yes, my lord. The subsequent development, my lord, them to amend in the repetition. So I don't have any objection, my lord.
So IA 123 your lordship can allow and dispose of.
And Mr. S. the senior counsel assisted by
IDAS.
MS IDAS, and counsel by the applicant oblique petitioner. By filing this application, the petitioner, the applicant has sought for amendment of the writ petition, amendment of the connected writ petition being WPC 93 of 2024. What is the proposed amendment?
Proposed amendment is indicated at the paragraphs 18A to 18D. That is at page 8 of the IA, paragraph 8. That
The-
you'll
Next paragraph, the proposed amendments. The proposed amendments
are indicated in paragraph 8 and 9 of the IA.
the proposed amendments in the writ petition, the connected writ petitions are as follows, huh? There are 8. There are 8
and 9.
There are 8, not 9. There are 8, huh? You quote one, huh? You just quoted here a bit, huh?
Well, the prayer has also to be amended. That's why it was indicated in paragraph 9.
Okay. Next paragraph, then we read next paragraph. The applicant has also further sought for amendment of the prayer portion, which are reproduced here in below, para 9, huh? I have considered the submissions of the learned counsel for the petitioner, applicant, and also perused the proposed amendments as referred to here in above. Mr. No, Mr. On having considered above I deem it appropriate. I deem it appropriate to allow the present application. No, before that. Mr. Aritsanabar Lalit, Additional Advocate General, for the respondents, opposite party respondents, submits that he has no objection to the prayer for amendment of the connected writ petition. Mr. Next prayer, then having considered the submissions and having considered the submissions of learned counsel for the parties and perusal of the proposed amendments, I deem it appropriate to allow the same accordingly. The IA is allowed by permitting the applicant to amend the connected writ petition, particularly. You just write down. Okay? Particularly. Insert by particularly by insert particularly the amendment at paragraph 18A, 18B, 18C, 18B, 18E, and in the prayer person is Roman 1, 2, 3, and also in the prayer person
As indicated in
as
para 9.
indicated at para 9. The IA stands allowed and disposal.
Now,
Yes,
the next case, Lordship, that is item number 9.
yes.
That is ready, my lord, that in that case, my lord, there is no IA, the pleadings are complete. Your Lordship may consider the writ petition at item number 11. In item number 11, my lord, 2 IAs are there, 93 and 94. These were filed by certain parties seeking impleadment, but they are also not pressing it. So that in that view of the matter, your Lordship may consider disposing the IAs off.
It's okay, we'll keep if nobody is representing, then it's not, because no order has been passed.
No. Initially, they filed the IA seeking impleadment. We filed our objection. And since thereafter, they have
It's okay, we'll not
disappeared.
pass any order.
Then in that case, it can
Let it
be
remain.
that remain. But in both
So
of
in
the
that case, we'll in all the writ petition, the pleadings are completed.
pleadings are
completed.
except the first one, now we will file the amended amended writ petition shortly. So
Then in that case, in first, item 8, writ petition. You heard Mr. Swens, Same, in view of the order passed in IA 123 of 2024, the petitioner is permitted to
file the amended.
file the amended, consolidated,
Yes.
consolidated, amended writ petition list within a period of
3 weeks.
3 weeks, list after 3 weeks.
Well, the date may be
My lord, since there is an interim order operating against my lord, so we need a early date and a fixed date, my lord, for final disposal.
3 weeks.
let it be on 4th of November, my lord. Your Lordship can fix the date.
You choose it.
4th of November. We are
My lord, for
otherwise-
final disposal, my lord, for final disposal.
We'll file within the period of 3 weeks. He may, if he wishes, he can file respond. And
We will say final disposal.
Yes.
So we'll
Yes,
say endeavor shall be made
Ah.
for final disposal.
For final disposal.
Final
I'm
disposal.
also- Well, I'm appearing in item number 10.
10, my lord.
In 10 also there is an amendment petition, my lord.
Okay.
So,
my lord.
No, we'll not say final disposal. We'll fix it for on the understanding that it will be this.
Yes, yes.
You make a mention.
Or your lordship can put one more sentence, endeavor shall be, my lord. That can be
It-
added, my
List,
lord.
list on 4th of 11th, 20, 04, 11, 2020.
my lord.
24. In item, see,
8.
8, huh? Since Mr. R.H. Nabab, learned additional advocate general, expresses urgency in the matter, endeavor shall be made to dispose of this matter on the next date.
Well,
My lord, there is an interim order that may be continued.
Interim order points earlier shall continue.
that is the main.
And in item number 9 also, my lord, the interim order may be continued. Till the
Same date,
next,
same date.
same date.
And then item 9. Buildings completed.
Pleadings completed.
Same.
My lord, item number,
The pleadings is completed. The pleadings completed. List the matter after 2 weeks.
On 4th,
Same date, my lord, on fourth, my lord.
Same date. Then
And
item 10,
interim order may be
my lord.
continued, my lord.
interim order to continue. Huh?
In item number 9, interim order.
Yes, item 10,
My lord.
10, my lord, there is a. I am, my lord, amendment. 10, I am appearing, my lord. There is a application for amendment of the petition. Subsequent events are there. So in paragraph 12, 10 and 11, we have said. This case 124.
10 and 11.
Yes.
No, my lord. 10, 11 again, I am appearing, my lord.
No, no.
11, you're.
Item number 10 in paragraph.
Item
10
number
and 11.
10.
Similar
Then-
prayer as made in item number 8, my lord. There is an
Same.
amendment arising out of the same item.
Is it?
My lord, same item.
Same, my lord.
Same paragraph.
No, paragraphs are different, my lord.
Paragraphs are 10 and 11.
You just went.
Yes.
Heard Mr. G.
G. N.
Sahiwala, learned senior counsel assisted by
AK Sahib.
A.K. Sahiwala, learned counsel for the petition. No, applicant, huh?
Applicant.
This is IA.
124,
Hey.
Applicant petition. 124.
my lord.
Yes, same order, we can pass
Well,
same order.
Only
The
paragraph.
paragraph will be different.
12, 8,
Paragraph.
12.
You just said, I think the IA 124. Parties will be different, same order, but paragraph will be different. You just see.
Paragraphs, my friend will also indicate to her.
Paragraph 10 and 11.
That will be at paragraph 10, huh?
10, 11, and 12, my lord.
10,
12 is the
11.
prayer.
10, 11.
And 12 also. 12 with the prayer.
10, 11,
And 12. my lord.
12.
12 is the prayer.
You just got that, huh? Then there's no prayer person?
Well, the
Prayer portion is 12.
Prayer 12, it is prayer. I put it.
At prayer person is
Ah,
prayer 12.
prayer 12.
You just change that paragraph number and prayer person and all, huh? That is paragraph 12. Same order. Then in view of the order passed so and so, huh? In item 10, huh?
Amended it petition will be filed.
Same order. Is it okay?
Same order, my lord. In item 10, read
What
petition,
it should be listed?
same day.
Same day. Similar.
In my lord, in read petition number 115 of 24, that same order may be passed as passed in my lord.
Yes, I have said so.
My lord.
And in so far as, my lord, item number 11 is concerned, my lord, in item number 11 also, there are two miscellaneous cases, two parties sought impleadment, but they are not pressing it.
So any affidavit has been filed?
Yes,
Yes,
no, in that case, the state's affidavit is awaiting, state's affidavit. Oh, the item number 227.
11.
Item number 11, WBC 227.
Heard Mr. So-and-so, learned counsel. Yes, Dr. Learned Senior Counsel assisted by MS Idas, learned counsel for the petitioner, huh? You want to file a affidavit on the prayer learned counsel for the parties, list this matter on 04 series.
Same that,
In
my
the-
lord,
in the
we file
meantime,
the affidavit.
the state respondents may file their
Well, they here also an interim order is operating, that may be
country
continued.
order was earlier. Yes, you just check it, huh? Don't mix it up. Have you understood?
Obliged.
IA is for what?
For recalling of the interim order,
What is
pass in
it?
favor of the petitioner, my lord.
Huh?
My lord,
We have filed our objection, my lord.
Hmm.
I have not received it, the objection.
Yes, objection is there. You have not received.
Not received. My lord,
Heard Mr. D.
My lord,
come to learned counsel for the.
there is urgency in disposing of this IM, my lord.
Tomorrow,
Even if,
day after.
Day-
We'll take it up the day after. Or are you not,
my lord,
you said you have not received the.
yeah, I have not
objection.
received, my lord.
Will furnish, my lord.
Okay.
While filing, my lord, it
How-
must be with the clerk, my lord. the
My
filing
lord,
clerk.
that itself is also one of the ground, my lord, should one of the ground, my lord.
My
After
lord,
this
they
obtaining the
duly-
interim order, my lord,
That's what I'm saying. Wow, how can
the
His-
petitioner were given one week.
His junior has duly received, my lord.
How?
It must be in the even received copy in the filing slip itself.
how he can file without serving the copy to you?
Yes, my lord. His junior has received.
We'll see day after tomorrow.
My lord,
If it is received by your junior, we'll file impose a cost on you. If it is not, we'll impose a cost on you.
I'll have to
Right.
extract the amount from my junior if they have released. Tomorrow, my lord.
Don't you feel shy of saying so?
Tomorrow, my lord.
Rather, you should pay. You are a senior.
But we also expect some
Huh?
diligence from our
Had
extra
Mr.
states.
D come to London counsel for the applicant, respondent, huh? Respondent. Not her, Mr. D come to London counsel for the applicant respondent submitted. He has not received the copy of the, he has not been furnished with the copy of the
Objection.
objection filed by the petitioner, opposite party of the respondent, petitioner. In view of the vote, let this matter be listed on third,
My lord.
Third.
after Gandhiji,
Yes, ma'am.
Gandhi Jayanti,
Yes, ma'am.
on third, huh?
If it could be
In the
listed tomorrow.
meantime, if no copies, no, in the meantime, the language council for the opposite party petition to furnish the copy of the objection, if not furnished already.
Much obliged.
My lord, interim order, my lord.
Interim
continue.
order first, earlier shall continue. What is the interim order?
My lord.
Transfer.
My lord, transfer, my
Transfer.
lord. He's my lord retiring on a
Why,
after-
petition will be decide the entire matter, what's there?
my lord, he's retiring, there's only 4 months left for retirement, my lord.
So we'll
Now
dispose
he's-
the
Yes, my
matter.
lord. Entire matter can be disposed of on
Let's see.
third, my lord.
We'll see it tomorrow.
Yes,
Day
my lord.
after,
And
day after.
yes, ma'am. Entire matter.
We'll allow,
Pension paper.
allow the writ petition.
Will have no objection if they are in fact.
Pension paper already started, initiated in the Nari division, my lord. Yeah.
No, my lord, he has been transferred to headquarters, my lord. Guideline, what is says, my lord.
Thank you, sir.
The
Thank you.
person
We'll
retiring
see
from
day
the
after
service should
tomorrow.
be.
We'll see day after.
Yes, my lord.
Deeply hospital.
What is this IA? Yes, what is this?
My lord, this is IA,
Hmm.
today better fixed for the hearing.
Of what?
My lord, the IA is made for the packet of the interim orders on the 16/8/2024. My lord, please see the interim orders. This is a mislead code, mislead before the dishonorable court, my lord. My lord, please see the annexures 1 and page 15. This is interim order passed by the dishonorable court. Here, my lord, please the operative part of interim orders, page 19. Page 19, paragraph, last paragraph.
Yes, where is this page?
Page 19, last paragraph. This is mislead by dishonorable court.
Yes.
Here, my lord, the prima facie case, this court of the view that under sections 3(1), under section 3(1) of the Act 2003, the elected member of the Panchayat Raj Institute can be disqualified firstly when such member voluntarily give up his membership of the such a political party. In such a case in hand, it is not the case when the petitioner had given up his membership voluntarily, rather it is case of the expansions. Secondly, the member can be disqualified in the prima facie view of this code when the elected member would absentee from voting or intentionally remain absent in any meetings of the concerned institutions. Even after any direction issued by the political parties. Here, my lord, under the Arunachal Pradesh,
He has resigned.
yes, resigns, my lord.
Resigned from
Resign from the
political party.
from the
Where it is?
BJP party.
Where is the resignation?
My lord, please see the resignation letters, annexure.
33.
Yes, yes, my lord. Come. Annexures 2 series, page
33.
33, my lord.
Badr Nabum. Hmm.
34 is a type copy, my lord. Again, 35 is also resignation letters.
Yes.
Thereafter, my lord, after the resignation from that political parties, I am a respondent number 2. I am a district president of the Bharatiya Janata Party of the Pakistans. I have been accepted the letter also, resignation letters. The letter has been already, I saw that before this last, this is a resignation acceptance letter, my lord.
How many petitioners?
My lord,
How many petitioners? Only one
no. 11 petitioners.
in this writ
Yeah,
petition?
yes, my lord.
In the writ
That out
petition?
of 11 petitioners, they have 7 have already given resignations.
Huh?
7 out of 11, the 7 members they have already resigned from the primary membership.
So who have been disqualified? Who?
My lord,
All 7.
7 are disqualified.
All 7. The ZPM.
Yes.
Jilla Parishad.
Gram chairperson.
Huh?
ZPC.
ZPC.
No, not Gram chair. Gram Panchayat members.
Gram GPC.
GPMC.
GPC.
Yes,
7.
7.
Chairperson Gram Panchayat.
2, 3 are the Gram chairpersons, or the rest are the Gram Panchayat members.
Where is the order of disqualification? Where the order of disqualification?
My lord, please see the petitioner copy.
all sevens have joined together as
Yeah,
a
my lord, this is,
petitioner.
I bring.
Yes,
My lord,
all sevens are the petitioners.
All 7, no, 11 are this.
11 are petitioners.
Then seven,
7 are the resignations.
Their contention is that
out of 11,
11,
seven
seven
have
Resigned.
resigned.
6 have resigned. They have shown 6.
6.
6.
Why are saying then 7? Where is the
I have-
separation?
I have filed objection,
Yes, saying what?
saying we have never resigned. To that effect, only after filing this IA, we come to know that our signature has been forged. To that effect, we have filed FIR also.
Okay.
And there was a series of hearing before the DC. We
So
repeatedly
this
sought-
application at page 33
yes,
is not your signature.
it's not my signature, page 33 series. And that to that effect, I have also, we
What
as
do you
7
say on
members.
Yes, my lord, very, very interesting. Thus, again, they are trying to mislead this honorable court.
It's not interesting, it's very
My lord,
serious.
is,
If
yes, my lord.
either of
Yes, my lord.
you are.
Yes, my
misleading,
lord,
it is very serious,
Yes, my-
not interesting.
Yeah. My lord.
It's a
yes-
serious matter, not
Yes,
interesting matter.
Yes, sir, sorry, my lord. My lord, the here is
Yes.
that already the petitioners have before stated that during the statement recorded and the learned deputy commissioner.
They are disowning, they are saying that they have not filed any resignation letter.
Yeah, that is why, my lord.
We'll call for the record.
No, my lord, this is already, this is the
Not from
original
you, we'll
papers.
call from
This
the
is
record
already
from the deputy commissioner.
That is already stated that I have resigned from the.
What is the state of the state?
Please, sir.
I mean, the deputy commissioner. You file it. There's a judgment of the division bench. That other matter. Recently,
Yes, sir.
last week, you have that.
Uh,
That will have a bearing on your merit of the matter. Have you come across
My lord?
this issue?
Yes.
I mean, is decided by the in other matter.
Yes, yes, my lord. Yes, yes, I have.
When? Last week.
My lord, other cases with judgments similar order may be passed. The Supreme Court of the.
When? That writ petition, writ appeal has already been decided by the division bench.
Yes, yes.
When?
Oh, that was not the single based decision was that.
I'm telling you, sir, that similar issues, voluntary resignation and all those resignation, voluntary giving up has been decided by the division bench of this court last week.
Yes,
With
order.
respect of the KE Panier district.
Yes, yes. The single based decision is with me, but the
Forget
writ
about
appeal,
the
writ
single
appeal is
bench.
not available with me. The judgment copies.
Single bench, division bench, you find out.
Yes.
Last week, you do have that.
Yes,
What is the name of that?
Lucas.
Lika
Songre
Lika Sange, Suri and others.
Chore, huh?
Yeah.
Lika Sangye Chore.
27.
So it's in view of the disputed or the claim and counterclaim,
Yeah.
we'll call for the records. We just cannot vacate the stream order.
Lordship, original records.
Obviously, do you expect that this court will call for duplicate record?
Because we are seriously disputing this.
That's what I'm saying. It's serious.
Yes.
If you, according to him, you have manufactured this resignation letter, it will entail serious consequences. Heard Mr.
Kiwi.
P. Bui, learned counsel for the applicant, and also heard Mr. Arko, learned counsel for the opposite for the petitioners, oblique petitioners. Only one IA. Next paragraph. The applicant has filed this application. Vacating the interim order dated 16/08/2024. passed in the connected WPC 334 of 2024. Mr. The essentially the ground of ground essentially the ground for vacating the stay order is that the petitioners have suppressed the material facts while obtaining interim order to the effect by not disclosing the resignation from the party.
Yes.
Mr. P. Boyd, learned counsel for the applicant, submits that the petitioner has not only resigned, but consequently, their resignation have also been accepted by the party, which facts the petitioner have not disclosed before this court while obtaining the interim order. Mr. Next. On the other hand, Mr. Arko, learned counsel for the opposite parties of the petitioner, submits that the petitioners had never submitted any resignation letter, and the resignation letter annexed in the IA is fake and forged one. Mr. Next one. Having considered the submissions, having considered the claim and counterclaims of the parties, MS Arbasar, London State Council, appearing for.
In IAM,
You are not in the appearing for
read petition, we are for 1 and 2.
respondent number 1, Deputy Commissioner.
One is Secretary Department Panchayat, 2 Deputy
And in that case, the respondent states is directed to obtain the record from the Deputy Commissioner of Pakistan. This matter of
A particular date may be fixed because of this call for the record. So
on 21 or 22. Because you two will be busy during puja vacation, puja holiday. 22.
22.
24 year old.
24. We'll see who has manufactured and who is bluffing.
Interim order.
Interim order passed, earlier shall continue.
Maybe the last.
Yes.
This is a tender matter where pursuant to my bids been submitted, I was found to be the L1 bidder, but later on, the bid was evaluated to be the most abnormally low, and then it was rejected, against which I had come before this honorable court. Now, during the pendency of the proceedings, the government came up with an memorandum. The copy was submitted for lawsuit on the last occasion. I think it's in the file. Memorandum dated 22 March 2024. In fact, the date is on the next page, 29 May 2024. So you got that? Now, by way of this notification or memorandum, what the government has done is they have constituted a committee wherein they say that they are going to re-examine the entire issue based on this rates that we have given. So now we are actually waiting for this committee's report. And till now, if a lawsuit will see, this committee was supposed to pass the speaking order, that serial number 2. Following the examination, the committee shall pass speaking orders recommending the acceptance or rejection of the bid in question within a time frame of 15 days. And this notification is of 29 May 2024. Second page, Lordship will see. Till date, the government is not coming up with anything. They have just kept the matter in a standstill position pursuant to this.
Your challenge is what?
My challenge is my rejection of my bid on the ground. They have rejected it on the ground that it is abnormally low. Now, when I challenge this, they come up with this notification. If a lordship will see serial number 1 of this notification, re-examination process. The committee shall examine whether the price quoted in the bids identified as abnormally low required justification to be sought.
Yes, it's on 22 March 2024. Within 15 days, you are supposed to have a
This may be taken up on 3 October.
third. You informed, are you appearing for standing counsel?
Yes, I'm appearing on behalf of El Permit.
El permit. Therefore, you inform him to bring on the report of the, or any decision of the, I mean, this is a committee. Any order or report of the committee is constituted under, in this, by this memorandum.
And for this package itself, Rupa package under the power department, it is for particularly for this. Once we file the case, they said we are going to re-examine it. Now we are going to revisit it. So if they are revisiting,
Third will.
can it be on fourth?
Third or fourth?
Fourth, Lordship.
Fourth or after vacation. You just see.
Urgency is there because they have just kept it like this. We are somewhere in the limbo now, just hanging. Nothing is going ahead. This honorable court may not also like to go ahead because they have said they are going to re-examine. So if they are re-examining, let them pass an order, whatever re-examination report is there. They can't keep it pending like this.
Third, Mr.
Yes, sir, my lord.
Yes, sir, learned counsel for the petition.
Impugn order is at page 192, Lordship, which I have challenged. Page 192.
It's okay, we'll just simply say.
If the Lordship will strictly order them to place it. It's been long now. That is my only submission. They themselves say 15 days. And it's like now 5-6 months now, Lordship.
And also, third, Mr.
Yes,
Yes, learned counsel appearing on behalf of Mr. El Permit, learned standing counsel for power department. Mr. A. Sharma, learned counsel, by placing the copy of memorandum dated 22/03/2024.
So there are 2 dates, Lordship. Next page, they have another date, 29 May 2024. I think it's 29 May. Because we filed the case.
Issued on
yes,
29/05/2024.
Yes, Lordship.
Submits that the state authorities have referred the matter by constituting 3-member committee.
Yes,
three
Lordship.
members.
3-member committee.
To examine the issue involved in this present petition, right?
The price bid that was rejected as abnormally
It's
low.
okay. Issue involved in this present petition. Mr. He submits that, however, assume that no speaking orders or report has been made available to the petitioner. Despite the fact that the committee was supposedly examined the issue within a time frame of 15 days. Mr. Next paragraph. Considering that the state has already constituted a committee consisting of 3 members by providing terms of reference which is invoke the issue in this writ petition by providing a time frame of 15 days for passing the speaking orders After examining providing for passing speaking orders, recommending the acceptance or rejection of the bids. The within a period of 15 days. The learned standing counsel, Mr. L. Perme, you inform him. Shall place on record the report of the, not place on record, the speaking orders of the committee is constituted for the purpose of as constituted by the state. Mr.
On the next date.
On the next date.
So we fix it on
List the
4th.
matter after
Nasib?
after list the matter
On 4th of October, let me have a chance on 4th of October.
Okay. List the matter on 24. Oh, sorry, 04/12/2020. Yes. You inform him. 4th of October.
Yes, yes.
Is he around? Will he be available
Yes.
on 4th of October? We met two.
There is a delay of 384 days in filing the connected review petitions. Your Lordship, I have given cited the grounds for delay at page 3, para 3, Lordship. Lordship, this honorable court, while disposing of the writ petition.
Yes, any objection?
Your Lordship, as far as I'm concerned, I have no objection.
Okay.
In the petition, I was for the petitioners.
Yes.
Objection on respondent number 4. I'm representing respondent number 4. We are not objection.
No objections.
Yes.
No.
In IA.
No objection.
Review?
No.
Both, you don't have any objection.
Yes. Yes.
Okay. Heard Mr. Heard MS B. Chokri, learned Additional Advocate General.
Yes, Your Lordship.
For the applicant. And also heard Mr.
L. Iralu for the petition, for the respondent 1.
1 and
2.
1 and 2, yes.
1 and 2.
Yes.
Sorry, for opposite party, number 1 and 2, and Mr. For respondent number 3, opposite party number 3. Right?
Lordship.
By filing this application under Section 5 of Limitation Act, Indian Limitation Act 1963, the applicant Deputy Commissioner has spread for condemnation of 384 days in filing the connected civil review petition. Against the judgment and order dated against the order dated 25/07/2023 passed in WPC number 70 of 2019. Next matter. MS B. Chokri, learned Additional Advocate General, submits that delay in filing the connected civil review petition for review of the order dated 2507/2023 is neither intentional nor due to the negligence or lapses on the part of the applicant. By narrating the following facts, which is as under para 3, huh? Page 3, para 3 below. Next para. Therefore, she submits that the delay of 384 days in filing the connected review petition within time, filing the review petition within time may be condoned. Mr. Next paragraph. Mr. So-and-so, for the learned counsel for the respondents fairly submits that they don't have any objection or condonation of delay of 384 days in filing the connected review petition. Next paragraph. Having considered the grounds to be German, which are grounds of the applicant to be German, comma, I am of the view that a reasonable cause has been shown by the applicant, which prevented the applicant to file the connected review petition within time. Next paragraph. Considering the grounds noted herein above and the objection and the no objection raised by and the and having not been objected to the condonation of 384 days in filing the connected review petition, I deem it appropriate to allow this present application based up accordingly. The delay of 384 days in filing the connected review petition is condoned according the IA stands allowed and disposed of. In review petition, huh? Same, huh? No.
8 and 9. To change to modify the phrase the deputy commissioner to the deputy commissioner notified.
What is this?
Our lordship here, when the
Your review petition is defective. Page 2, come to page 2.
Page 2, lordship.
Yes. Who is the applicant?
The applicant is here, page
Who is
1.
Yes, who is the review petitioner?
The deputy commissioner.
Yes, where it is?
Page number 1. Deputy Commissioner, Government of Nagaland, Dimapur. Is the applicant.
Page number 1?
Yes.
Page number 1?
Yes, lordship. The bottom line.
Okay. Heard MS Bisopri. Same, huh? And also heard Mr. So-and-so, corresponding number 1, 2, and Respondent number 3. Both, huh? This is next para. And review petition for a review of review petition for review petition against the review petition of the order dated 25/07/2023 passed in WPC 70 of oblique 2019. MS. This learned counsel to the petitioner. Review petitioner submits that
Para 6, 7, and 8, paragraph, page number 6, Your Lordship.
submits that by the notification dated 20/12/2021, the district of Samukadima was created and Kirha village falls under the jurisdiction of newly created Samukadima district. However, neither of the contesting parties apprised this facts to the court at the time of hearing, and for which the Honorable Court, this court has, while passing the order dated 25/7/2023, had directed the petitioner to file a fresh representation before the Deputy Commissioner Dimapur. List of the Deputy Commissioner on receipt of the representation is to conduct the spot verification at Dag number 7 by giving notice to the petitioner as well as the Assam Rifles, and thereafter to take appropriate action on the basis of the verification report in accordance with the law within a period of 1 month. Mr. She submits that since the jurisdiction of since the Kirha village falls under the jurisdiction of Samukadima district and not under Dimapur district, which was not brought to the knowledge of this court, this Honorable Court, at the time of hearing. This court had directed the applicant, the petitioner, Deputy Commissioner Dimapur, to conduct the spot verification. Mr. Therefore, she phrased that the Deputy Commissioner Dimapur be replaced by the Deputy Commissioner Samukadima. At paragraph 7, 8, and 9 of the order dated 25/07/2023. Next paragraph. The learned counsel means so and so and so and so. Learned counsels for the respondents had no objection for such a review by replacing the name of the Deputy Commissioner Dimapur to Deputy Commissioner Samukadima. Next paragraph. Having considered the submissions and considering that the Kirihai village has the Kirihai village falls under the jurisdiction of the newly created Samukadima district, I deem it appropriate to allow this present application, present review petition to the effect that the name of the Deputy Commissioner Nimapur be replaced by the name of the Deputy Commissioner Semukadima. Accordingly. At paragraph 7, 8, and 9 of the order dated 25/07/2023. Wherever the name of the Deputy Commissioner Dima is recorded, the name of the Deputy Commissioner Semukadima shall be replaced and corrected. Mr. Review petition is allowed and disposed of. Yes.
We have filed an IA, Your Lordship, that
Yes.
is in pursuance to the direction that was passed by this Honorable Court dated 26/3/24, Your Lordship, to implead one Sri Ikentau as a private respondent, Your Lordship.
Okay. Cannot have any objection.
No, ma'am.
Objection, no. MS
R. Taku, Your Lordship.
R. Taku, learned counsel for the applicant. And MS K. Wang, learned state counsel for the respondents. Opposite party respondents. Then in there is applicant and petitioner. Next person. By filing this application, the applicant has sought for impleadment of one Sri Ikentau as respondent number 3 in a connected writ petition 11 WPC 11/2024. Disco on 26/06, by the order dated 26/03/2024 has allowed the applicant writ petitioner to implead one Sri Ikentau as he is a necessary party having been found to be a necessary party as the respondents had cancelled the land possession certificates of the petitioner on the basis of the affidavit submitted by Sri Ikentau. Next one. Since the petitioner, public petitioner has challenged the legality and validity of order dated 13/07/2022, by which the land possession certificate has been cancelled on the basis of the affidavit submitted by Sri Ikentau, by one Sri Ikentau, I deem it appropriate to allow this application accordingly. Accordingly, Sri Ikentau, have you given the address?
Yes, Your Honor.
Where it is?
That address is not in the IA, Your Lordship.
Hmm?
The address of the, that is not in the IA, Your Lordship.
How do you take these steps?
Your Honor, that, if allowed,
We-
then I will take the steps.
Applicably. Anyway, we implemented a respondent number 2 in the connected writ petition. In the connected WPC 11/2024. The applicant states allowed and disposed of. In this writ petition, in view of the order passed in ISO and so, the learned counsel for the petitioner is permitted to file amended post title and file amended post title and other requisite documents. Thereafter, notice be issued, return to the newly implemented respondent number 3, returnable by 4 weeks. The petitioner to take appropriate steps.
Much of.
Yes, sir.
Yes, my lord, I am appearing for the first time, my lord, for respondent number 3.
Okay.
So 4 weeks maybe.
That will complete.
Your Lordship.
Heard Mr. So-and-so, learned counsel for the petition. Mr. B. Pitcher, learned counsel enters appearance on behalf of respondent number 3. List of affidavit.
I've already filed my respondent number 1
Mr.
and 2.
T. Tagum, learned counsel for the learned standing counsel for standing counsel
Yes, ma'am. Trims.
for trims
Health Department.
is learned standing counsel for
Health
health department.
Department, but represented Trims.
Department standing counsel. No, trims is separate.
Yes, ma'am. I've been authorized. That there's an order.
Learned counsel for respondent number
1 and 3, 1 and 2.
1 and 2. Submitted that he has already filed the counter affidavit.
My lord.
Mr. B. Pitcher, having been entered appearance today, is granted further 3 weeks, 3 weeks, 4 weeks time to file
4 weeks.
affidavit. 4 weeks, yes. This after 4 weeks.
Lordship, this is an interim, Lordship.
Interim order pass earlier shall continue.
Good job.
My lord, 23, I need some 1 week times to file affidavit.
Heard Mr. So-and-so, learned counsel for the petitioner. Mr. G. Tarak, learned standing counsel RWD is granted further 3 weeks time to file affidavit.
Your Lordship, there is an
2
interim,
weeks,
Your
2
Lordship.
weeks.
2 weeks, huh? Interim order plus earlier shall continue.
Much obliged. Then item 24, 25, 26. Otherwise, our affidavit is ready. But there was some typical mistake. So we are, so.
So the
One-
interim-
Otherwise, it's ready.
let it be on 4th of
Yet
October.
to file.
If not otherwise.
Because
We are supposed to file today, but there is
no
some.
stay order in this matter. This is relating to road construction
And Mr. A. Sharma,
on 4th of October also.
separate order, huh? But same order. A. Sharma, learned counsel for the petitioner. Mr. G. Tarak, learned counsel for the petitioner. And the learned standing counsel RWD is granted further 2 weeks time to file affidavit in it.
I'm appearing for respondent number 5.
In item, all item.
All the
In the same, Mr. D. Soki, learned counsel appears for respondent number 5.
5.
Same order, separate order. List after, list on.
On 4th of October also. 4th
After
of
2 weeks.
October. No, it's already ready. He says he was supposed to file it today. So he can file it on Friday also.
After puja.
Okay.
After puja, if there is no stay.
There is no,
No,
that is why the urgency,
That's what I'm
Lordship.
saying.
That is why the urgency. Let it be on 4th, Lordship.
Yeah.
I'm coming on 4th.
Let it be on reopening.
He come
It will be too hectic.
before court very late and now he's saying he's not there at all the orchestra.
See, if there is no stay.
Yes, Lordship. That is why the
I'm not-
urgency.
This court is not prejudging,
That is true.
but then
But then a
you may not get relief. So don't take.
So
that.
therefore, I'm trying to find a
So-
way to get
so-
the matter
so
disposed in a
don't
quick
take chance.
manner. So since he's saying that if it was ready.
Off the record, I'm saying,
Yes,
don't
Lordship.
take it otherwise.
I understand.
After puja,
Lordship will give a date.
you decide the date.
After reopening? On 17th. 17th?
17 is no.
17 is vacation.
Vacation.
17, you have to come to my court, my residence.
Not 17. Yes, let it be on 28 then.
I have no problem if they are ready. In the residence also, for hearing of the matter. On
I can also come. We also have vacations in Guwahati at that time. 28 Lordship.
20.
28.
28.
28.
All the three matters. Obliged.
Same order.
For admission.
But
yeah.
for admission. For admission. For admission.
My lord. This. My lord, this case I find very interesting, my lord.
Interesting.
Yes, my lord.
How?
My lord, interesting in the sense, my lord. In the record, my lord, it has been shown the accused has been the purportedly statement of the accused is purportedly recorded under section 364. Basically, there's wherein it is shown to have been admitted. Now, 364 talks about the CRPC talks about the translation of the judgment, which is not connected. And neither it is the case of plea of guilty. And the sole conviction is based on the statement purportedly recorded under 364 of CRPC.
What is 364?
It relates to the translation of the judgment, original judgment, translation of the judgment. Language.
There's a wrong translation.
No, even no such at all, man. It's not connected at all. Now, under what provision of law this accused has been examined? If it is treated to be examined, it is treated to be assuming that it is the plea guilty. The plea guilty provision has not been followed. So it is not a case of evidence at all. In this case, that the statement purportedly recorded under 364 cannot be treated as evidence. It is not evidence at all. And one part of the point at consideration taken by the trial court is he has admitted, well, the accused was examining under 313 of the CRPC. And in the 313, although the requirement of the law says that the specific question against the petitioner with regard to the implication specific, the evidence that has to be put to the accused, giving opportunity to explain. And if it's not done, then that evidence cannot be relied upon. Now, so far 313 of the CRPC is also concerned. It's vague and general question and identical, which even cannot be in that aspect, my lord. The even evidence cannot be relied upon. So,
is this by executive magistrate?
Earlier executive magistrate.
Conferred with the judicial
Yes,
magistrate.
yes, prior to the separation.
What more we can expect?
My lord, that is what.
Have you paid the fine?
My lord, since there was a stay, my lord, and
Stay of the
yes, conviction. And in the meantime, the counsel who was earlier conducting the case, he has expired in the meantime, and we have
So-
taken over, we have entrusted him.
In that case, after
Because it was under the 45 regulation.
But then you have mentioned all this, the magistrate had mentioned 364.
Yes.
I don't know, it,
And
apparently it appears to be,
313.
it appears to be the depositions.
If
Wrong quoting of petition, how to.
if my lord, if it is a deposition, then it is to be the evidence. Now, whether such deposition, whether it can be treated within the definition with the evidence, but that will have to. And my respectful submission, it is not a case of evidence, even not a constitute
Guided by the spirit, nothing more than that, CRPC.
We'll see.
conviction.
Okay, my lord, after vacation.
There's a stay
My lord.
of the
Conviction, my lord.
conviction.
My lord.
Have you had the contact with your, the
I could not, the ones,
petitioner?
but in between I could not, but after expiry of the council, they approached my lord.
Okay.
It seems to be, my lord, this interesting case, I personally find.
On the prayer of Mr. T. Tagub, learned counsel for the petition, list this matter after 4 weeks.
My lord.
Mr. Deepangi, learned counsel for the
Private response.
private response is present.
Deeply honored.